This is the Financially Simple Podcast, a show dedicated to destroying the complexities of money for today's small business owner. And now, here's your host, pizza-loving, certified financial planner, Justin Goodbread.
Welcome to Financially Simple. This is a finance show for small business owners about money, how it works in our business and our personal lives, and how we can build wealth to be financially independent. I'm your host, Justin Goodbread. Today is episode number 31. Today's episode is titled, The Documents and the Terms. Now, look, I typically don't do this, but this is going to be a longer episode. In fact, we're going to split this particular content up into two episodes, episode number 31 and 32. So today's part one of two parts. Many years ago, when I was 18 years old, I purchased my first company. I bought a small landscape company from a contractor. And this contractor was a good businessman. He's still a great friend. The purchase price wasn't much, a couple thousand, a couple of 10 figures. And I thought I really could get away without having a lawyer review it. Yeah, rookie mistake. But at the time, the legal cost seems insurmountable. I mean, when you're purchasing a business, let's say for $10,000, I felt like the risk could be minimal. Now, fast forward 18 months after the transaction was completed, I received a letter from the state of Georgia. The previous owner had not paid the last portion of the unemployment taxes, and I was the person responsible. See, in the agreement I signed, the seller actually had good counsel, and he made sure that the seller was protected in the event that we overlooked something. And in fact, we did. Now, the seller was not trying to be nefarious. He wasn't trying to pull wool over my eyes in any ways, but he had to get a lawyer. And the contract said that he was indemnified. So think of it. You sold your business years ago, and you're on a 6-week sabbatical. You're in Alaska. You went whale watching to look at icebergs to see what I've always wanted to see, the Aurora Borealis. You went to see the Northern Lights. And you get a call from your lawyer saying, you're responsible for a liability that you assumed years ago? Maybe it's a statement that you probably don't want to hear. Maybe it's a liability like I dealt with. Maybe it's a state liability. Or maybe it's something like a lease agreement where you sign and you were the personal guarantee on the lease. How many times have we signed personal guarantees, right? Maybe it's a liability caused by your business that you weren't aware of and it's come back to bite you. See, I call these circumstances loose ends. You ever heard tie up the loose ends? As we enter into the point of the documents where they're going to be drafted, you'll need to build a list of all the areas which could have potential liabilities. Don't worry. If you hire a powerhouse transition team, they're going to help you. They're going to ask you some questions. But in yourself, you need to go ahead and dig through the closets to see if there's any skeletons in here, right? Here's some questions you may want to ask yourself. What agreements have you signed that are still in force? Have you bought a piece of equipment? Maybe there's a loan in force. Maybe there's a agreement with a outside consultant. Maybe there's a graphic design. I saw one time a business owner gave rights to his website away for 5 years because of the agreement, and he wasn't aware he couldn't transition the website. Well, that caused some problems in the transition. Did you make any personal guarantees? I saw one where the seller had actually made a personal guarantee with the phone book company and had their business advertised in the phone book. And if you ever dealt with phone book companies, they're pretty ruthless. They'd already put the print out, and they were trying to collect on the debt, which the seller had promised he'd sell. And it wasn't insignificant. It was tens of thousands. And so ultimately the seller had to pay the personal guarantee. Do you have any looming liabilities which could cause you problems? Are there any disgruntled customers? Maybe disgruntled employees that you've terminated? Product failures? Are there any possible looming lawsuits out there? You're like, Justin, this is depressing. Yeah, you want to dig up all the skeletons, friends. You got to get them all on the table. You got to let your transition team know about it. Now's the time. Now's the time for you to take the inventory and take action. You don't want to wait until after the sale. See, your legal team will work with you, and they'll release drafts that have things like indemnification in there. That's a big word. We'll deal with that. They may even require insurance in some circumstances. So that leads to, what is a release? What is indemnification, and why are we dealing with insurance? So, in my financially simple terms, a release is just what it sounds like. Perhaps the biggest way I can say release is, have you ever gone fishing? We have a little trout river by our house here in the mountains of Tennessee, and I love to go catch trout. And you'll catch trout, and then you release them. And that little trout's out to do his own little thing, not to worry about me in any way. And so that's what a release is. Maybe your lawyers draft something in there that the buyer signs saying, we're releasing the seller from these obligations. That's a release. Or they may have an indemnification clause, which says, you know what? Should these things come up, the seller is going to indemnify the buyer. They're going to make the buyer whole. And then you decide, well, do I want to take on that risk? That's an indemnification clause. Or they may say, you know what, we need insurance. Well, depending on the type of liability, insurance may be needed. One of my business friends purchased a company, and he was informed about a potential employee liability. Because of that employee liability, and it was going to end up being a lawsuit, a sexual harassment lawsuit, the buyer was required to have insurance in place to cover the potential liability if it should arise. It wasn't the issue with the seller's person because it was a part of a company, but we made it a fact to make sure that the buyer had the right amount of insurance to cover if there was a lawsuit that should arise. And it did arise, by the way, and the insurance company stepped in and dealt with it. But without insurance and without addressing that particular skeleton, then my business friend would have been left to deal with that liability after the fact. So the release, indemnification, insurance all help to provide you some peace of mind. But when you sell your business, there are other agreements that you'll sign that could come back to haunt you. So there's going to be a lot of agreements that you're going to sign. But these are the most common traps I've seen. So I hope this will guide you. And we're going to be dealing with a lot of documents over the next little bit. The first agreement we're going to deal with is the non-compete agreement. It prevents you from working with a competitor. Maybe when you sell your business, you don't want to go out in competition and the buyer's saying, hey, look, we don't want to have the seller, the current business owner, go in and team up with one of our biggest competitions, take his trade secrets that we're buying and helping our competitor come and play. So that's a non-compete agreement. And we deal with this as business owners. We may even have them in place now for our employees or even our business partners or some phantom interest in our company. But make sure that the agreement allows you to work with businesses that don't compete. I'll give you an example. I know a nurse practitioner which is currently in the straits of a non-compete battle. Their former employer is claiming that she is competing because she went to work with another doctor's office. Now, what's interesting is not the fact she went to work with another doctor's office, it's that the opposing doctor's office doesn't even compete in the same area of medicine of the company she left. They're in two different parts of the health industry. So you want to make sure when you sign a non-compete that it doesn't prevent you from working with any business. I have seen non-competes that try to do that. You also want to make sure there's a limit of time. Now, not only did this nurse practitioner have an agreement that said don't work with anybody else, but now she's 4 years after the fact trying to fight a non-compete agreement. Make sure you have a length of time. A lot of times you'll see it maybe 12 months or 18 or 24 or 36. It just depends on your particular business. But you want to have a definitive timeline on it when you can go back and compete. You also want to make sure the non-compete terminates in the event of a breach of contract. For example, I know a business owner who sold their business and then the buyer refused to pay the remaining obligations. The non-compete terminated and the seller started another business directly competing with the buyer. So because the buyer refused to pay the seller any money, the seller's like, well, fine, I'm going to go out and buy my business back. He wouldn't sell it. Okay. I'm going to go out and take all my customers, my knowledge, and go take all your customers from you. And sure enough, that's what happened. So you want to deal with the non-compete, but make sure it's fair. You're going to have to sign one. You will. Make sure it's fair.
You are listening to Financially Simple, destroying the complexities of money for today's small business owner.
You're also probably going to sign a non-solicit agreement, and this is another document which governs you, the seller. The idea behind it is to prevent you from having to go out and poach the current employees, the customers, or the vendors of your particular business. But you'll want to have the ability to hire an employee which is fired from the job. Or maybe you know somebody. I have a client of mine that he sold his business and he was going to start a different business altogether in a different industry altogether, but he had a right-hand man that these two have been together for years. And so part of the non-solicit, they excluded this right-hand man. They went ahead and realized that, I'm going to call him the vice president, okay? The vice president of the company was not going to be there long-term. Now, did it affect the purchase price? Of course it did. Did it affect the agreement? Of course it did. But in the non-solicit agreement, we had to make sure we did a carve-out and explain that that was an area that we were going to allow. So that's a non-solicit agreement. We dealt with the word indemnification earlier, and basically it's the agreement that you're going to sign to protect the buyer if someone claims that you did something wrong while operating the company. Obviously, it's fair. It's fair to protect the buyer from illegal activity like fraud or tax evasion or infringement, but you shouldn't have to indemnify the buyer for standard operating items. So this is where your attorney is going to double check and make sure that you're not signing something that's just ridiculous. You're going to have confidentiality agreements. We all have confidentiality agreements. Basically, you're going to agree to keep your secrets secret. I've signed several confidentiality agreements in my life. You'll need, however, to be able to tell your CPA how much money you made. I was in one particular agreement, and the people said, no, you can't tell anybody about this. I'm like, well, time out. How am I going to tell the IRS I did this particular sale? Well, that's okay. Well, can I tell my CPA? Well, yeah. I said, okay. Can I tell the attorney? Well, yeah, but that's it. Well, time out. What if I want to go borrow money for another investment property? Can I tell the banker or the mortgage broker? Well, yeah. So you got to be careful with confidentiality agreements. Now, your legal team and your financial teams, they're going to have an understanding of how you're going to be compensated. You've got to be able to tell your financial planner, hey, here's how I sold my business and here's how I'm going to get paid. Like I said, I had one that someone put in front of me one time, said, I can't tell anything to anybody. That dog won't hunt, people. That's not good. So you never know. You'll see all sorts of things. The confidentiality agreement, make sure it just keeps the secret. And you got to have a little bit of propriety here as well. And you got to use a little bit of common sense. Sometimes common sense is lacking in these worlds. Another one that you could deal with is called intellectual property agreements. Many times they're called IP, intellectual property. I called it intellectual property, an IP attorney friend of mine who I send all of our clients to. And I said, man, I've never signed an intellectual property agreement, but I'm reviewing all the different things that I could see, and it seems to be a document. He goes, yeah, Justin, we have a lot of IP agreements out there. I said, can you tell me what it is? He goes, well, basically, whenever you have something like a patent, if you will, that you've signed, you're basically going to give that patent to somebody else, and you're going to give the right out. I said, okay. I said, what areas of concern should I have? He goes, man, you need to make sure that there's carve-outs for consultants. I'm like, what do you mean? He goes, well, for example, let's say that you design the intellectual property on your own time. You're not on the company's time, and you designed it. Well, you want to make sure there's a carve-out for that particular detail. Or if you work with an outside consultant on that particular patent or that particular design, let's say it's an engineering design, you had an engineering firm, you want to make sure that the intellectual property agreement is there to protect the consultants that you might have hired. Oh, that's a lot of agreements. And you're like, Justin, look, there's a ton of data you just spouted out. I mean, I'm like drinking from a fire hose. What can I do? All right, so let's break today's episode down into these last little steps. I'm going to give you 4 steps that you can deal with when it comes to the documents. Number 1, listen to your advisors. They are paid to think about the worst case scenarios. They're paid to ask questions which hurt. They're paid to think about worst case scenarios which could come back and harm you financially, emotionally, reputation-wise. They're there to help you. We've already laid the groundwork that your core team, your attorney, your CFP, and your CPA, they're going to be there. Listen to your advisor. Listen to what they say. They deal with this on a regular basis. That's number 1. You're like, Justin, that's common sense. You would think so. I think in this episode or in this series so far, I've mentioned 3 or 4 people that just refuse to listen to their advisors and to their own demise, ultimately. You want to listen to their advisors. Is this a blind faith? No, it's trust but verify. Let's use Reagan-esque type numbers. You're going to trust them, but you're going to verify their data. These people have gone through this before. You can ask lots of questions. Ask as many questions as you can. Ask the same question 6 different ways and see if the answer changes. That is, if you've got good advisors, they're not going to be blowing smoke. They're there to help you. So that's number 1, listen to your advisors. That's common sense. Number 2, take inventory. What are you worried about? What would you be worried about if you were the buyer? No one knows your business better than you do at this time. No one knows it. Now, granted, the buyer will eventually know your business just as much as you do, and they're going to find the skeletons. They're going to find where you buried things. Look at it from the buyer's perspective. Write down everything you can think of that even it seems so small, and let your advisor determine if you have risk or not. The third thing you can do is prepare to negotiate the details. There's going to be a little give and take through these agreements. If you have an ugly baby, You're going to have to get creative. What do you mean, Justin? There's an old saying, you're going to hear me if you listen to this podcast any length of time, you're going to hear me say, you never tell a woman her baby's ugly. You never do that. If you ever tell a woman your baby's ugly, duck and run. And we've seen some ugly babies, haven't we? You never tell a woman her baby's ugly, but sometimes you got to tell a business owner they got an ugly baby. Business owners more than likely aren't going to slug you like a mom would. If you have an ugly business, if you have an ugly baby, if you've got some problems, be prepared to negotiate. But it doesn't mean give in. It doesn't mean that you're going to fold and say, okay, buyer, whatever you want. No, you can be creative, and this is where your team's going to come in, and you can negotiate. And number 4, don't forget about your team. As the founder, more than likely you have employees which will remain and be exposed to potential liability. I've seen this happen firsthand. I watched a business owner who told us about an ugliness, and for propriety's sake, I'm not going to get into all the details, but he told us about an ugliness. He didn't tell us that he had members of his executive team involved. And after the ugliness was found out, the executive team, who he set up with a 5-year guarantee contract, it gave the buyer, now the owner of the company, rights to terminate the executive team over that one issue. And so everything that the executive team had been hoping for over that period of time was now just for naught. And it all could have been avoided had the seller of the company told the advisors all the details instead of trying to pick and choose what he thought was best. So don't forget about your team. As the founder, you're going to have employees who are going to remain, and they're going to be exposed to liabilities, if there are any. Take care of your team. So that's it for part 1 of this episode. Episode number 31. We're going to continue this on episode number 32. We're going to dive down strictly into the purchase agreement and what to look for and how it involves and how it takes. So guys, that's it for this episode. As I always say, life is hard, life is fun, life is complicated. Money doesn't have to be. Let's continue to make our lives at least financially simple.
You have been listening to the Financially Simple podcast. The information in this show is for informational purposes only. This show is not investment advice. Instead, seek help from a competent financial advisor. Justin Goodbread, CFP, is an investment advisor representative of Heritage Investors, a registered investment advisor.